A Delhi-based entrepreneur says his U.S. visa was denied under Section 214B. He posted the refusal and his response online, and it blew up. And whether you agree with his tone or not, the reason this story matters is simple. 214B is one of the most common reasons people get refused for a visitor visa, and it can hit students, employees, founders, and even people who look very established on paper. By the end of this video, you will know 3 things. 1. What a 214B refusal actually means in plain English. 2. Which applicants are most likely to get hit and why. And 3. Exactly what you can do before your interview and after a refusal to improve your odds next time without guessing or panicking. Here is the part most people miss. A 214B denial is not the officer saying you are a bad person or that your business is not real. It is usually the officer saying you did not meet a specific legal standard on that day, with that evidence, in that short interview window.
Now, quick context.
Reports say the entrepreneur is Jasveer Singh, a co-founder and CEO of a matrimonial platform based in Delhi. He said his U.S. visa was refused under Section 214B, and he called it ironic because he has been running the company in India for years, employing people, and paying taxes there. Yet he says it was still considered not enough proof that he will return. He also claimed he tagged the U.S. ambassador and criticized training at the New Delhi consulate. And he raised a concern many people share: whether social media scrutiny is playing a role, and whether critical posts could hurt approval. Other founders reportedly shared similar experiences. I want to be careful here. I cannot verify each individual claim from a viral post. But we do not need to verify every detail to explain the bigger, real issue. What 214B is, why it happens, and what applicants can control.
So, what changed?
In many viral conversations, people assume a single denial means a new official rule, or a blanket crackdown on a nationality, or a secret blacklist. Usually, that is not how 214B works. Section 214B is part of U.S. immigration law that creates a presumption for most visitor visa applicants that the person may intend to immigrate unless they convince the officer otherwise. In plain English, the burden is on the applicant to show they are a genuine temporary visitor. This is where people get denied. The officer is not only asking, "Do you have money?" or "Do you have a job?" The officer is asking a bigger question. Given everything I see in this application and this interview, is it more likely than not that this person will leave the U.S. at the end of the trip? And that decision is made fast, often in just a few minutes. The officer has the DS-160, prior travel history, prior visa history, and whatever notes exist in the system. They will ask a handful of questions that are designed to test consistency and credibility. Why are you going? How long? Who is paying? What is your work? What do you do day to day? Why this trip now? What do you have that anchors you back home? Small detail that changes everything. You can be a successful CEO and still fail the temporary intent test if your trip purpose sounds open-ended, your itinerary is vague, your financial story is unclear, or your overall profile looks like someone who could easily stay, work, or shift their life to the U.S. Now let us break down who is affected versus who is usually not, because this is where confusion spreads. Most at risk in a 214B world are applicants who have one or more of these factors. First-time international travelers with little prior travel history. Applicants with vague travel plans like, "I want to explore opportunities or meet some people." Applicants whose funding story is messy, like someone else is sponsoring but documentation is unclear. Applicants with weak home ties, or ties that do not look stable in the officer's eyes. And applicants whose answers do not match what is written on the DS-160. A founder or entrepreneur can fall into this bucket in a very specific way. Here is why. A founder often does not have the classic proof anchors that consular officers are used to seeing, like a long-term employment letter from a large company, a predictable monthly salary, and a clearly defined leave approval. Founders may have fluctuating income, complex ownership structures, and international ambitions. None of that is illegal, but it can make the story harder to summarize quickly in an interview. On the other hand, some groups are often less likely to get a 214B refusal, though no one is guaranteed. People with a strong, consistent travel history who always returned on time. People with a clear, narrow purpose of travel and a credible itinerary, specific meetings, specific dates, and clear funding. People whose work, finances, and family situation are stable and easy to explain. Again, less likely does not mean impossible. Here is a common edge case. You can have a great income and still be refused if your purpose sounds like you are going to job hunt, pitch investors without clear structure, or attend multiple open-ended events with no defined return date. Myth versus reality number 1. Myth. If I show I have a company, I will automatically be approved. Reality. A business can be a positive tie, but the officer still needs to believe this specific trip is temporary and that you have compelling reasons to return promptly. A business can also signal you have international aspirations, so the explanation has to be clear. Now, why is this happening, and why does it feel like it is happening more right now? There are a few non-dramatic reasons that can create a surge in 214B stories. 1. Volume. When more people apply, more people get denied, and more denials go viral. 2. Uneven preparation. Viral trends make people apply for conferences, business trips, or tourism without strong planning, which increases refusals. 3. Risk management. Consulates operate under fraud and overstay prevention priorities, and officers are trained to make quick decisions with limited time. 4. The macro environment. Anytime immigration policy becomes a bigger political focus in the U.S., public attention increases. But a focus in public debate does not automatically equal a new official rule for visitor visas. Here is the part most people miss. Consular decisions are discretionary and individualized. Two applicants can look similar and get different outcomes depending on the total picture, the interview performance, and how consistent the application is. Now let us address the social media question, because this is all over the viral posts. Do consulates check social media? There have been periods where applicants are asked to list social media identifiers on forms, and screening practices can include open source checks in some contexts. But it is risky to jump from that to the claim that deleting critical tweets will improve approval odds. Myth versus reality number 2. Myth. If I delete political posts, I will get approved. Reality. A visitor visa is usually decided on temporary intent, ties, and credibility. Deleting posts can create a different problem if it looks like you are hiding something or if it conflicts with what you listed on an application. The safer approach is not to try to game the system. The safer approach is to be consistent, truthful, and focused on a clear, legitimate travel purpose. Also, remember, a 214B refusal is not the same thing as being found inadmissible for fraud or misrepresentation. A refusal under 214B is typically a failure to meet the burden of proof at that time. That is why people can reapply, but they should not reapply with the exact same story and documents and expect a different result. Now, real-world consequences. This is not just a bruised ego online. A denial can disrupt business travel, conferences, investor meetings, client onboarding, trainings, and family plans. It can also create second-order effects, missed opportunities, last-minute cancellations, and reputational stress if your role requires travel. And there is another practical consequence. The way you react matters. If a case becomes viral, it can create pressure, but it does not create a legal pathway. Tagging officials might get attention, but it does not replace the core requirement, proving temporary intent. Example scenario number 1. A composite example. A founder in Bengaluru applies for a B1, B2 visa to attend meetings and a tech conference in the US. On the DS-160, the trip length is listed as 30 days. In the interview, the founder says, "I may stay longer if meetings go well." The officer hears open-ended. The founder also says a US-based friend will host them, but cannot clearly explain who is paying for what. The founder has not traveled internationally before. Even if the company is real, the overall pattern can trigger a 214B refusal because the trip purpose and return plan do not feel locked in. Example scenario number 2, another composite example. An employee at a startup is sent to the US for training. The employer provides a letter, but the employee cannot explain what the training is, where it is, or how long it lasts. The DS-160 says one city, but the employee mentions 2 different cities. The officer sees inconsistency. That can end in 214B quickly. So what should you do now? Especially if you are a founder, a professional, or a frequent traveler who is suddenly worried. Here is a practical do this and avoid this checklist. This is general information, not legal advice. Do this. Build a one-sentence purpose of travel. Not a story, a sentence. For example, I am traveling for 5 days to attend pre-scheduled business meetings with X company and return to India to continue running my team. Keep it specific. Do this. Align your DS-160 with your spoken answers. Dates, cities, purpose, and who pays. Consistency is credibility. Do this. Prepare a tight itinerary. Even for tourism, have a reasonable plan. For business, have meeting dates, conference registration, and a return date that makes sense. Do this. Be ready to explain your role and your income simply. If you are a founder, explain what the company does, how long it has operated, your team size, and your personal compensation in plain terms. Do this. Show clear ties that are easy to understand quickly. That can include ongoing business operations, family responsibilities, property or lease obligations, and long-term projects that require your presence. The key is not just having ties, it is explaining them clearly. Avoid this. Do not present an open-ended trip. Words like explore opportunities, maybe meet investors, see what happens, are red flags because they sound like you are not sure when you will return. Avoid this. Do not overtalk. Short, direct answers are better than long speeches. Avoid this. Do not bring questionable documents or exaggerate. Never invent bookings, invitations, or employment details. A 214B refusal is frustrating, but a misrepresentation finding can be far more serious. Avoid this. Do not assume wealth guarantees approval. Officers are assessing intent, not just bank balance. Now, if you already received a 214B refusal, what next? First, take a breath. Many people are refused and later approved. The main question is whether anything material will change before you reapply. Do not reapply the next day with the same application unless you can clearly explain what is different. A better approach is to do a short self-audit. What was my stated purpose? Was it specific? Were my answers consistent? Did my funding and itinerary make sense? Did I accidentally create doubt about returning? If you reapply, be prepared to present a clearer, tighter case. Sometimes that means a shorter trip, more defined meetings, a stronger itinerary, or clearer financial documentation. Sometimes it means waiting until your situation changes in a meaningful way. More travel history, a more stable business pattern, or clearer obligations at home. Here is the part most people miss. The officer may not keep your documents. They may not read a thick file in the window interview. So your goal is to make your case understandable in under 2 minutes. Your documents should support your story, but your story must stand on its own. Myth versus reality number 3. Myth. If I get refused once, I am blacklisted. Reality. A prior refusal is a data point, not a lifetime ban by itself. It can make the next interview tougher because the officer will ask what changed, but many people do overcome it. Now, what could happen next, and what should you watch? Because people are talking about crackdowns, and you need practical watch points. Watch point 1. Appointment and processing backlogs. When demand spikes, consulates can become more selective, and interviews become more compressed, which can lead to more 214B outcomes. Watch point 2. Consistency in messaging from official sources. If there are official updates, they typically appear on U.S. Embassy and consulate websites, the Department of State travel and visa pages, and official social channels. If you see a viral claim that does not link back to an official source, treat it as unconfirmed. Watchpoint 3. Your own risk profile. If you are a founder planning travel, consider whether another visa category is actually more appropriate for your long-term plans. But do not self-diagnose based on social media. If your travel is complex, talk to a qualified professional. And one more micro hook. The highest risk moment is not the interview itself. It is the weeks before, when people submit a DS-160 with vague language and then try to improvise at the window. Let me recap calmly with 5 things to remember. 1. A 214B refusal usually means you did not convince the officer you are a temporary visitor on that day. 2. Being a CEO or founder does not automatically protect you, because the officer is judging clarity, credibility, and return intent, not status. 3. Social media rumors are not a strategy. Focus on consistency and a clear travel purpose. 4. If you are refused, do not panic and do not rush. Reapply only when you can explain what is materially different. 5. Verify information through official U.S. government sources and avoid viral claims that cannot be confirmed. If this helped, subscribe and turn on notifications. We track practical immigration and travel rule updates in plain English, and we focus on what you can do next without fear-mongering. And if you have been through a 214B refusal, share one thing you wish you knew before your interview. Your comment could save someone else a lot of stress.